Hello, hello, good morning. Welcome, John.
Welcome.
Welcome to our webinar.
So how come it
Yes,
looks
sir.
the other way for me?
Well,
Just
you gotta trust, you have to trust the process. The same thing that you tell
listen,
your
listen, you're a
clients,
professional. If you're telling me that the world sees it okay, I know it's okay.
it's either that or you have to go to the eye doctor. I don't know. No, I'm kidding. So
Okay.
it's all good. Good morning. We're live, John. So thank you all for joining our webinar today. Let's perhaps wait, a couple of minutes uh, and allow attendees to join the webinar. And yes, we're super excited to talk today about what's going on in immigration rights. What are the challenges? What are the opportunities? And what is the name of the game that we have to play? How are you doing today, John?
I'm doing great, busy. Busier than ever, but it has challenges, Marco, but it has opportunities also to understand, like you said, what are the current challenges to get around it. But doing good.
Good to hear and super excited and to, as always, learn from you. And let's, let's get started here with yeah, the webinar. Okay, so I'm going to share my screen and okay, so welcome to our webinar. Thank you, John, for joining us today. And today we're going to be talking about avoiding visa denials. We're going to be talking about E-2s, L-1As, EB-1Cs, and EB-5s. We're going to be talking about practical strategies that work today. And I was telling John, I'm doing this webinar from Switzerland. I'm in Geneva attending the ALAB Rome District Chapter Conference, which started today, and it's always mind-blowing. It's a great chapter, a lot of practical information, high-level information that's taken back to the office, and of course sharing with you all today, because especially today there was a panel on Is and Ls, and it was pretty interesting. I'm going to be sharing a couple of things that I learned today, and I will be posting in the next few days about the few things that I learned today. So, my name is Marco Scanu, and I am the founder of Visa Business Plans. And I came into the immigration world by accident. I was born in Venezuela. I've been an entrepreneur for more than 35 years. And when I migrated to the US, my immigration lawyer, or the immigration lawyer who did my O1 visa and business, said, look, I don't usually include a business plan in my O1s, but your sponsor is a startup, really small company. And I think that I want to include a business plan in your O1. So long story short, I ended up getting involved with my background in business and finance. I got involved in the business plan and said, look, this is really interesting. I was looking for a change. I came from the world of hospitality, restaurants, food operations, food manufacturing, retail stores, franchising, and so on. And man, time flies. After 17 years, we've done around 9,000 cases, and we keep learning every day. And I'm always super thankful because everything that we do today, thanks to many lawyers that have taken the time to educate us, and all the conferences that I attend is, it's a great opportunity to learn. So at the end of the day, our number one job is to help attorneys win cases. And John is one of those lawyers that I have learned a lot from. John, every time that you talk, I listen. So why don't you go ahead and introduce yourself and let the attendees know what you bring to the table. Thank you, John, for joining our webinar today again. Thanks.
Thank you, Marco. John Pratt. I've been practicing law for over 20 years. Graduated from Tulane University, and I've been exclusively practicing immigration law. So I have seen, the growth or the changes that have been present in immigration law from 1998 to the present. I'm a partner at Kurtzman, Tselly and Pratt in Coral Gables, Florida. We have offices in a couple states. We've been growing in DC and in New York now. Um, I have the fortune to practice with my partner in Washington, D.C. is Carl Rich, who used to be the Assistant Secretary of State of Charge of Consular Affairs worldwide. So, some of the challenges that we're discussing as consular processing, et cetera, we're at the forefront, with Carl's coming into the firm and bringing his expertise. So glad to be here, Marco. I've been involved in different areas of immigration law, specifically employment-based immigration for many, many years, and EB-5, E-2s, L-1s. We have a very robust federal court practice. So, when an EB-1C or an L is denied, or an E-2 or an EB-5 is denied, we actually go to federal court and challenge some of those denials under Administrative Procedures Acts. We've also litigated even other areas, an adjustment of status that went all the way to the Supreme Court. And obviously, at this point in time, we are doing a lot of litigation in habeas. And that's for detained people. And what's been happening lately is, for example, there's a crossroads of the immigration enforcement and unemployment law or employment immigration law. For example, people in EB-5 and other areas, people even with concurrent adjustments being placed in removal proceedings, even though they timely file, etc. So a lot of challenges, like you said, Marco, but we've been involved in all those areas, including in the federal court litigation aspects of some of these visas that we talked about.
Perfect. Thank you. Looking forward again, as I said before, to learning from you and let's see. We're going to be talking today about the E-2 and different strategies and the L-1A in the office petition and also the EB-1C. Then we're going to be talking about the EB-5 and different strategies. Then, a very important section of our webinars, which is case studies, like real cases. We're going to be talking about 3 cases that we worked on together, right, over the years. And then we're going to have about 10 minutes at the end of the webinar open for Q&A questions. So, John, for all ears about the E-2 visa.
Yeah, well, when I started in immigration law, Marco, and I think we were talking about it a little bit before we talked, yeah, there were business plans, but the business plan was generally done by the foreign national, and it was a hodgepodge of, and then luckily professionals like you enter the business because, in at least of what I've seen recently, and I'll start with the anecdote of again when we're preparing for this that we recently know of a case where someone invested a substantial amount of money, about $1 million in a restaurant that will be operating. It's not open yet. They've already made the investment. They're buying the kitchen and tables and everything like that. And they went to their consulate to get the E-2 visa, and the E-2 visa was denied because it's not an operating business yet. It's operating in the sense that the corporation's open and they got bank accounts and they got capital, but the restaurant's not open serving food yet. And they denied it based on that. So to me, what's more critical than ever right now is to show a viable business. And in the past, we would have business plans that says I'm going to be a consultant and I'm going to open an office, and it was kind of like the E-2 new office, right? In the sense that I will be employing people, I will be doing XYZ as a service for to sell, etc. And we've seen more denials, and it started with Biden and denials with 214B and others, which we'll touch upon. But, what I'm advising, my clients when they're doing an E-2, et cetera, is, it would be ideal if you actually have a real operating viable business, brick and mortar. You got W-2s, you got 1099s, you got employees, you got income. And in some cases, obviously, go buy a business, use your business lawyer to buy the business and do the due diligence because you don't want to write the wrong business. And make sure that it could pass this, because I think more important than ever, at least what I'm seeing, is the consulates are interested in a real operating business that you're making, that the investment is substantial, is not marginal, and all the requirements for the E-2. But they want to see that you're actually making an economic impact, not some nice work of literature where they don't know if you're going to do anything in the United States. And I think we all know businesses that operated that way with all the great intentions of my consultancy, and I never consulted with anybody, and I never hired anyone, and I never really did any economic. So, a lot of people are undecided about, well, what business do I do? And on one strategy that we successfully use, and there's been some pushback, but we successfully used through the years, and with you, Marco.
Sorry for interrupting. So I would summarize the first concept I would call it the ka-ching factor, the cash register, the sound of the cash register,
I like
right? That. So you can ask your clients going on, where is the ka-ching factor in your business? So sorry for interrupting, but I thought
no, absolutely. I mean, what product or service are you going to sell, or are you selling already? And I think that more important now, that are you selling? What product or service are you selling? Who's selling it? Who is it sold to? What are your customers? The reality of a business operating for profit. I think is more important. I guess what you call the catch-in, because that's a register saying ching when you buy your coffee or you buy your tire or buy whatever you buy. But a lot of people, for example, are interested in, I want to, for whatever reason, children, economic turmoil, insecurity in their countries, that I want to do this, and what business where do I invest? What business do I do? Some people come with ideas of, I'm going to be doing the business that I'm doing at home, not knowing whether that business will be successful here so one strategy that I've always done is to create a holding company that invests in different businesses.
Mm-hmm.
And I'll illustrate one actual case that happened to us during the pandemic. We had created a holding company, and this was an Argentinian family who owned different movie theaters. And they own about 4 different movie theaters. So we had a holding and we had 4 different movie theaters. The one industry that, Marco, that was really, really killed by the pandemic was movie theaters.
Mm.
And they were forced to shut down all 4. And, they went bankrupt because they were forced to shut down because nobody could go to the movie theaters. But because we had a holding company, we pivoted for them to buy gas stations. Now they had the capital to do it, but they went into gas stations because they thought that was an inelastic product, that there's no way people are going to stop using gas stations, even if it's a pandemic again. So they bought gas stations. But again, the holding company concept has also helped out where, for example, you have someone that has their dream business to do in the United States, but you go a holding company, maybe you buy a franchise, maybe you buy an existing business, and as another subsidiary, as part of the whole group of your total investment in the United States, you have another subsidiary that's doing your consultancy, for example, or you're doing the other things that you're attempting to do. So we have successfully used a holding company with subsidiaries model in a number of ways to correct problems, to make further investments, to create more employment, and obviously to show that the substantial investment and not marginal overall is, and we use the holding company as the E-2 vehicle for the visa. I know that there's been some pushback by USCIS on this concept, and I can address it more, but I do think that in the EB-5 is recognized. I think it's the holding company model is recognized in the business world throughout.
Exactly.
Obviously, when you have different businesses that have different operations in order, and there's business sense to do it, it protects you against liability. For example, if you have a holding and a restaurant, and then you have another business, if someone breaks a leg at the restaurant, they're not going to be able to touch the other business because they're separate entities. So there's
Exactly.
economic business reasons to do it. I think it's a mechanism that's been used in the business world, and it's a strategy that I think could be very successful in obviously opening and operating and trying to get an E-2 visa. If you could move to the next slide, please.
There you go.
Some things we have seen, and it started during the Biden administration. 214B denials on E-2s, and I never saw an E-2 denial on 214B, Marco, until again, the Biden administration. I mean, I just didn't think. Now, we know, and most immigration lawyers think, a 214B denial is only for non-immigrant intent or immigrant intent. And yes, but if you read 214B, there's other sections there that may or may not pertain. But with the first one that I saw was someone that had been on an E-2 as a child because the parent owned an E-2, very successful business. So the child aged out, turned 21. So what that did is gave him about $1.5 million to invest in his own E-2 business. Now, this person had been living here since he was a little child. And the father gave him the money. The father gave him the money in the same type of business that the father was involved. He owned over 51% of the business, etc. But he was a young man, did not have a college career. And it shouldn't be any difference, because what if I just win $1 million in a lottery? Why? I can still invest in it and I can still get an E-2, right? But anyway, so his E-2 visa was denied on 214B, and his B-2 visa was canceled on 214B. And when you get a denial on 214B at the consulate, they don't tell you why they denied it. So but again, what we saw and what we believe is that the consular officer did not believe that the person really had an intent to go back to his country of origin. If anything, if the E-2 was not successful, if it went bankrupt or whatever the case may be, even though you don't have to have a foreign residency abroad, we started seeing 214B denials. I saw then 214B denials on renewal of E-2s with substantial investment in the millions from Europe. So I think obviously the consulate started, either, obviously applying a different standard in the sense that having no foreign residency abroad into believing that the person was just here, on a permanent basis. And again, the challenge with the 214B denial is that you got consular non-reviewability. So people come, okay, sue them, John. I can't sue them. Okay, you get a FOIA so I can find out why they denied it. You may not be able to get it even through a Freedom of Information Act. Why did they apply 214B to your specific intent? Now, one way we have worked around that, and it's not a perfect, but we have seen 214 I have seen 214B denials at the consulate on getting the E-2 visa. I have not seen 214B denials on a change of status. And I wouldn't say to beat a consular processing. I think I would say that change of status is another option that you have. Like, for example, if you're an F1 and you have status, you could change it to an E2 status. If you are on an L and, maybe, the company, and we will talk about E2s and Ls and EB-1Cs, that there's sometimes you could do all of it. But let's say that you have an L company that had no relationship to your E2 and you're going to get fired. Well, maybe you could change it to an E2 investor. So there's different ways, or you are an H1B and you're aging out. So there's different ways where if you're in status, you could then change status. And as long as you don't go get the visa outside of the United States, then you don't have to go through the consular processing. And so sometimes, in some circumstances where we thought, depending on the country of nationality, depending on other factors, where consular processing could present challenges. Because at the consular process, you have two problems. 214B denials, or possible, but you also have administrative delays. They didn't issue your visa because they put you on 221G. And so, again, doing a change of status has been one option that we have done successfully, and I have not seen 214B denials in a change of status. To be honest with you, so again, it's something that we need to talk to our clients. But understanding one thing, that if I do a change of status and then they want to go see grandma for Christmas, then they're going to have to apply for that E2 at the consulate. So it doesn't really matter that they did a change of status. But again, some people want to stay longer, etc. And those are options that obviously that could be explored. I guess if you turn to the next slide, and I think you have expand on the holding companies for ease.
Exactly. In fact, I believe, John, that the first, if not one of the first cases with the holding companies was with you. And the first time that I saw it, I went, wow, is this even doable? I mean, this is amazing. Look, being an entrepreneur, understanding how someone, might have a business idea, but then once they actually start running the business, then they say, no, wait a minute, I thought that this business was good, but look, I found another business that's really great, but I want to do this other business, or, serial entrepreneurs. So who is the holding company a good option for serial entrepreneurs? People who have always itching to start a new business and they're perfectly fine running different business, right? And they don't want to get in trouble with with immigration service. So that's one. But then you have clients who say, oh, look, I don't know if I should do business A or business B or maybe C or A and B. So that's another option that gives you flexibility. I mean, that's what I love about the holding company model, right? But of course, you have to work with an immigration lawyer who knows how to do it, and that will help the investor navigate the minefield, right? To make sure that they don't get in trouble. Anyway, when we're dealing with an E2 visa business plan for a holding company, we view our business plans as a risk management tool, right? And this is why, again, I go to so many conferences to understand what's going on and new trends and so on. So some of the key questions that we ask when we're doing that business plan for holding companies, okay, is that we see control of the underlying entities. And again, we're not immigration lawyers, but we've done so many cases that we kind of understand what are the things that trigger hey, John, there might be an issue here because your client doesn't own 50% of the company, or they don't have any other ways of showing control, that type of thing. So we always are very careful reaching out to the lawyer handling the case, saying, hey, we have this holding company, 2, 3, whatever number of underlying entities. We're going to make sure that you envision all of them being part of the business plan, or maybe you know already that company C is not going to meet the requirements because either the investment is too low or whatever. But then the way we treat each underlying entities, we're going to make sure that each underlying entity meets the substantiality and marginality requirements, right? Like, it's like, let's say we have a holding company with 2 entities. We're going to make sure that there's basically 2 mini business plans within the business plan, but each business plan checks the boxes of the 2, right? Now, another question that clients usually ask, hey, Marco, what is the best business for an E2? And, the answer, lawyer-like is, it depends. And anyway, as you know, for some reason, we always want to think and analyze how do visa officers or immigration officers think. What is their background? So what I've learned over the years is that brick and mortar, as you said before, businesses and now real and operating businesses with the ka-ching factor are the ones to go. I've learned over the years that businesses that officers can relate to, like the dry cleaner, the restaurant, or maybe a business that sells products that has inventory. It's easier for them to understand than the AI, solution builder. You have many legit businesses around consulting and services, but generally speaking, I think that's easier for an officer to kind of feel like they can touch inventory, they can touch a brick and mortar location. And also, from the business plan point of view, it's looking at a business that requires an investment. Because launching, as you said before, a consulting business, yeah, that can be a legit business, but it's a business that you can launch with a $500 investment. So the challenge is always, how do you spend, how do you commit funds in a way that makes sense for in the context of the business, and makes sense and checks the boxes of the E-2. So it's always a challenge. It can be done, but it requires an additional layer of how can we make this investment happen? Whereas, again, opening a restaurant or selling products online, it's easier to show that investment in a business that is easier to understand. And as you said before, buy an existing business with a track record and employees, that's easier. It's going to cost you more if you buy, as you said, the right business. And another option, of course, is a franchise. And just like everything in life, you have good franchises and bad franchises and everything in between. So it's always very important to work with professionals in the field that can help you identify, or help your client identify the right franchise and the right business for sale, which is something that, by the way, we also help clients with. And lastly, I want to talk about alternative non-cash E-2 investments. And even though, again, we're not immigration lawyers, lawyers who have been working with us for years say, oh, but you guys are like immigration lawyers. So yeah, we have to understand the FAM, at least in a way that allows us to really grasp how the FAM is going to impact the business plan. So over the years, we've worked on interesting cases where you can use inventory as part of the investment. We've worked with restaurants, for example, in France or Canada, they close their operation overseas, or they have an excess of equipment and they bring restaurant equipment, and done the right way with a CPA and an independent opinion of value of that equipment, they can open a business. But also intangible property, where we have worked on cases where intellectual property or the market value determined by a CPA with experience, assigning value to IP, that was a big part of the investments. So that was an interesting case. But then we worked on a couple of cases over the years where the market value of this is from the FAM, manufacturing contracts generated by an asset, right? Again, only a couple of them, but it's doable, of course, working with an immigration lawyer who knows what they're doing. Let's
Let
talk
me just
about
say,
L.
right,
Yes,
before
go
we
ahead.
move on to L, let me just say a couple of things on what we discussed, though.
Yes.
I'm always thinking litigation, because when I go to court and I have to litigate a USCIS denial, the record is closed. And whatever an immigration lawyer says is not evidence. And I'll repeat that. Whatever an immigration lawyer says is not evidence. However, if there's a statement made by an accountant and by a business lawyer, it is evidence because they're experts. I'm an immigration lawyer, and I can tell you what the immigration laws say and the regulations. I am not a business lawyer, and I am not an accountant. I will not do fair market value evaluations. Accountants do, or maybe Marco does that, and professionals do that. I cannot tell you what is the current market value of your contracts. Accountants do and other things. So when I am doing this, I tell them you hire a business lawyer to buy the business, purchase the business, do the due diligence. I'm the immigration lawyer. Create the entities. I don't create entities. They'll have their business lawyer to create the entities. They'll have the accountants to make sure that they're doing their filing taxes correctly. But having a holding company also has business reasons that a business lawyer can help you with. And the example of, I have the dream to make this app. This app could take off, but I could make an app out of my garage. But that app may be worth billions. You don't want to have an entity that then has subsidiaries, because if that restaurant is a subsidiary of that company that's doing that app, and one guy breaks a leg, they're going to touch everything. That's why you have different holding companies for limited liability protection, and there's a billion reasons why having a holding company in the business world is the proper way. That's why operating companies, the big Fortune 500s, have holding companies that have divisions. Okay, so again, there's using the right team of professionals, including the business plan writer, is part of the overall strategy for E's and L's. Let me talk about L new office petitions. We have seen, at least in my experience, a huge incremental attack on L's. I used to do earlier in my career dozens of L's. Now I'm in a handful. And especially new offices, especially they're not brick and mortar, especially they're not, and it's like this business plan. And then, and you know, in my career, I've seen more attacks over and over, even though you get that 1 year to open. You get that 1 year to open, and it could be just a business plan. So we've seen a lot of denials for new offices on just business plans where they're not operating, kind of like the same thing I'm seeing on E2s. I've seen it, you know, so, you know, it's in the statute. I've done them and succeeded, but I think that they're being attacked a little bit more if you just have a business plan and an idea of what you're going to be doing. And I also have seen the delays in that new office. And what I mean by that is you get the USCIS to approve it, but then you got to go to the consulate, and the consulate puts you in 221G territory. And then what happens if you go over the year? Or what happens if the consulate says, oh, by the way, your business plan says you should have opened now your restaurant? Is it open? No, they're waiting for me to get there. So, you know, the business plan is a map, and things are supposed to happen at stages. So, you know, obviously, you know, you got to be, you know, more careful. The business plan, which Mark is going to go into, you know, based on verifiable sources and data, is critical. You know, another thing we've seen is obviously where it's just hierarchy. Who's on top? Are you a manager and executive? And who is at the bottom? What type of education do they have? What type of work experience do they have? Does the salary measure it with the hours that they're supposed to work, the entity, the capitalization of the entity, and they obviously go a lot in your job duties. And this is why I call it death by 1,000 cuts. If they ask me, John, what do you do every day? Well, today I'm doing a webinar. Tomorrow I'm doing a brief. The next day I'm attending an interview. The next day I'm at a removal hearing. I don't do the same thing. So if I had to put percentages, what percentage is that? In 1 month, I may have 5 hearings. Then for 50% of my time may have been in trial court. At a different month, maybe 50% is just doing visa work. But we're supposed to put these percentages, and a lot of business people just have a hard time understanding. These are the duties, this has to be the description, and a lot of times they get into this nitpicking, and killing you to death of the percentages and what you said you did, etc. The other thing that we have seen is them checking social media and other open source things. So if I say on my L that I'm the manager, I cannot have on an open source or SunBiz that says that I'm the director. I may be doing the same duties, but titles are important, duties are important, titles of people are important. And then that goes back to checking with your accountant. You can't say on your tax return that you were the director when you say on the L that you were, or your EB-1C that you were the president, because you signed it as director. So everything has to be coordinated, everything has to match, and having this hierarchy and educational levels and salaries. Now, some clients tell me, how many employees do you need? I generally like to have over 10. Why 10? Why did I make that number? No, if 10 is good enough for an EB-5, I think it should be good enough for an L or an EB-1 at a minimum. So I like to have 10 full-times. That's just what I operate under my brain, because 10 full-time jobs is good enough for EB-5. But then I hear 10. Okay, I'll have 10 receptionists. No, hierarchy on your business. You can't have one president and 9, secretaries and 9 receptionists. It has to make economic sense. It has to make business sense of what product or service you're selling and who is performing which duties, because you have to describe it. The other thing that, and I don't know how you deal with it and you can touch upon, is you tell me what my employees do. This is where I say, actually, no. Just like I told you to hire an accountant, just like I told you to hire a business lawyer, you better hire a business plan writer. And that business plan writer will work with you in doing the duties and the description and the hierarchy, and that everything makes sense, because having the proper business plan writing has to be part of the team and the strategy.
Exactly. That is spot on. And one more thing that I want to add, which is, it's important to understand the history of the L. The L was created in the 1970s for huge companies, the way the companies run in 1970, right? Which were all these layers and so on. And, business has evolved. Nowadays, you have flat organizations. So you have the reality of many companies, so they're flat, like a rectangle. That's how they operate. But the law was created where the whole org chart was a triangle, like with different layers. So that's another challenge to keep in mind. But and that's what we address when we do a business plan. As we always say, there's business realities and immigration expectations, and they're like oil and water. They don't mix. Okay. So what are the main differences that we see between an L1A and an EB-1C business plan? From a core idea perspective, the L1A business plan for a new office is, let me try to prove future viability, right? Although, as you're saying, with the current adjudication standards, it may be better to show a business is already with the catching factor, right? That has higher staff and so on. But that's basically the concept. For the EB-1C, it's, proof to me that there is an already established executive or managerial structure, and there's an important difference between those two structures. I'm not going to get into that, but it's key to really understand from an organizational chart perspective the difference between an executive and a manager. So the second difference, stage of the company, an L1A's new office petition is, clearly for earlier stage or newly formed entity, and the EB-1C for a more mature operating company. The focus of the narrative for an L1A is we will build a team, right? The beneficiary will eventually direct or manage others. For the EB-1C, instead, it's we already have a team and a structure, and the managers are managing either people or a function, or the executives are directing through at least one manager. At least the triangle that we're talking about. Financials from an L1A perspective, L1A in the office business plan perspective, the projections must be credible, but not yet proven. However, and this is today at the ELA conference here in Geneva, the L1A panel, they spoke extensively about a new trend where the USCIS is coming back asking, where exactly did this number come from? You don't just throw numbers right in your business plan. You got to defend your numbers, which thankfully has been our approach and way of doing business plans, because again, I come from the business world, and whenever you present a business plan to an investor, they're going to ask, what are the assumptions behind these numbers? So we have to treat, I would say today, an L1A business plan as an investor grade plan. At least from the numbers perspective, we have to be able to prove and defend reasonably the numbers. Financial for the EB-1C is the historical numbers matter more. Show me the money, right? Show me the revenues, the profitability, the financial viability, and the whole concept that revenue should support the staffing and the structure. Last but not least, I like to talk about risk. For the L1A, there is more room for uncertainty, right? It's about promising credibly that the standard will be met. For the EB-1C, forget it. It's very low tolerance for uncertainty, and the business plan is expected to show that the business has already met the standards. Now, since I'm not going to say we're running out of time, but almost, I'm going to skip this part here, except for one point that I do want to share, again, from the panel today on is and else. Two critical points, right? Again, as I said before, your business plan has to be ready to defend and answer the question, where did the numbers come from? Show me the assumptions. Show me that you're using credible sources. Show me that you're using industry benchmarks. And second, when it comes to job duties, which is something that we've been doing for years, is the importance of, look, vague job duties, they don't work anymore. And I get it, especially for new office petitions. I know, because I've been an entrepreneur for many years, small companies, they don't even have their job duties. That doesn't exist. People don't have time for that. They don't believe in that, right? But the point is that the vague job duties don't work anymore, and using action verbs, actually showing who is doing what, as you were saying before, John, who's responsible for directing, managing, who's doing the work, the frontline employees, who's doing the work, right? That's extremely important. So using action verbs, and last but not least, the more details, the better. We were talking about this, John, before started the webinar. Each and every single case is taking more time, and it's basically getting more and more and more granular details. So
let me just say a couple things before
yes,
we move on to the EB-5.
Yes.
I do think, because I do litigation, and I've done litigation whereby the person had an L and an L renewal, and they get denied the EB-1C, and you're like, how is that possible? And they denied the EB-1C saying you were never a manager, and you're not a manager now either. Now, wait a second, but you already adjudicated twice that I was a manager there and a manager here. How could you challenge that? They can't. And the fact that you said I had an L will not get you winning your EB-1C even in federal court. And we had mediation in an EB-1C whereby the federal magistrate said, look, which small company, and that company had about 17 employees, which I didn't consider was a small company. To me, an L-1 or an EB-1C with 6 people, 5 people, and it depends on the salaries, obviously. That's why I want 10. That's just me. Again, and there's nothing in the law that says a number, but the magistrate said, which company that's this size would win for you, USCIS? And what they said is not this one. And we don't care. See you in court. We're not mediating. See you in court. And eventually we lost because there were inconsistencies. And one of the inconsistencies that USCIS picked up on the description of duty, and I think that they did it by AI, is who opens the door in your office? No one has a description of who opens the mail, who opens the whatever. So there's a gap in your description of how, because you get mail, don't you? So who opens it? So is it that you are, because you have to be primarily managerial or executive? Who does that? So again, I think that, description of duties has to make sense, etc. And you cannot just simply rely on the EB-1C because you got the L. Just a couple of points. We're running out of time, so we'll move into the EB-5. Let me just say some of the highlights. Most of the EB-5 that I do is regional center. Why? Because you have to prove indirect job creation. So you have regional center, where you invest in a regional center. They have projects. You're kind of an indirect investor. You're more of a passive investor, although you have to have some management duties. You have some management duties, but not like in a direct investment. In a direct investment setting, you have to create 10 full-time jobs. That's W-2 people, not 1099, qualified workers with I-9s, etc. Now, it's 10 full-time positions. One mistake that people make in the EB-5 direct investment is, I have 10 W-2s. That may not be a full-time position, guys. And I'll give you an example. So my business has a receptionist. So employee 1 is a receptionist for 3 months. He or she quits. Employee 2 becomes a receptionist for another 2 months. He or she quits. Now, in a year, I may have 4 W-2s, 4 I-9s. How many jobs did I create? 4? No, 1 full-time position. Because now what USCIS does is they say, well, wait a second, employee 1, that 1099, I'm sorry, that W-2, because they cannot be 1099s, W-2s. That W-2 show that that person only made X amount of money during the year. That's a part-timer. Then you have to explain, no, they were not part-timers because they didn't work all year part-time. They only worked for 3 months and it was replaced. So you have to have this chart, which I use accountant, to track positions to employee as turnover happens. You also have job sharing. For example, I may have a 1 full-time position, the receptionist, but employee 1 works from 9 a.m. to noon, and employee 2 works from noon to 5 p.m. That's 2 people, 2 W-2s, 2 I-9s, 1 position. So you have to have this grid over time, maybe 5 years, maybe 6 years. And if you have a lot of turnover because you're in a restaurant business or anything, it becomes very problematic. It becomes very labor intensive. And well, what if I could never hire 10 people? I only went to 9. Well, you're not going to win. You got to create 10. You got to create 10. Second area, source of funds. I've become an nightmare. I use forensic accountants. I don't do this. I'm not an accountant. I use forensic accountants, and there's different strategies. They're doing things with commingling, depending on where you're coming. So, for example, I earned my income. I made $1 million last year. Okay, fine. Where did you put it? In the Bank of America account. Okay. So you earned $1 million, but you know what? We noticed that you had other money there. Yeah, I had another $100,000. Well, where did that come from? So now I have to vet that. So in a lot of cases, once the forensic accountant sourced the funds, and this is the same for direct investment or regional center. Once we know this is where the money's coming from, I put it in a virgin bank account that has no other money, no commingling. So then it goes into the new commercial enterprise and the entity that will be used as the vehicle for the EB-5. I discussed the direct investment with the regional center at a very high level. Source of funds, again, I am not interested in doing the business without a forensic accountant. Why? 2 reasons as a lawyer. Number 1, they're trained to do that. And I use a forensic accountant that's what they do. That's what they do. I did it for the Securities and Exchange Commission. So they're trained to do this. Number 2, if I have to litigate it, that's evidence. What I say is not evidence. I'm just a lawyer. Number 3, it protects me. It protects me from liability of doing a bad job because that's what they're trained to do. And in some cases, we found out that that's not the proper way. Then we're going to have to pivot and find if we find another source of funds that may be proven to immigration to satisfy. By the way, there's source of funds also on the E-2. And I use accountants to do that too. They're not as robust as EB-5, but in EB-5, they're doing a lot, and they're doing a lot of attacks. And they're doing a lot of attacks on source of funds even at the renewal stage or the I-9 stage. One other area that's been very troubling is in 2022, they passed the RIA, the new law on EB-5, and it has a component on national security. They could deny it on national security and discretion. And what we've seen is certain nationalities are going really after Chinese nationals who work in the high-tech industry to say that you're a national security risk. The problem is that there's very limited federal court review, if at all, and it's a lot of innuendo. So we're fighting a number of these at the I-9 stage with experts, former CIA, FBI. You have to again engage the proper professionals. And there's some entities that I work with that have that type of services, and obviously they do their own vetting because these are professionals. Just like when you hire a professional doctor, they're not going to tell you, yeah, you got injured. They're going to tell you their assessment. Sometimes it could help, but we're seeing an uptick, and the I-5, the security denials could come at the I-5 to 6 stage and at the I-9 stage. So you really need to have, these experts to try to put the record to try to increase your possibilities of winning. I guess you next slide, Marco, and you'll talk about a solid business plan under EB-5.
Yes, the EB-5 business plan is, it's case law, but kind of the standard is a matter of how. And I always, like to highlight that it's, clients ask, how many pages does your business plan have? Look, some people think the more pages, the better. But I guess it's a look, it's not like when you're in high school, at least, I went to high school in Venezuela where you would think, oh, the more pages, the better. So you would just copy and paste whatever, right? And that was your paper. But no, it's about detail. It's even in the USCIS training manual, the emphasis is on detail, not length, right? And extremely important, it has to be credible and realistic. Again, always ready to answer any question. So when, whoever writes a business plan has to think, okay, I have to be ready for an RFE that challenges anything in my plan, and I have to be ready to provide a solid answer to that question. So that is the right approach, anticipating the type of question that they may ask. That includes using verifiable sources, right? And two very important things that we've seen over the years. We're frequently contacted by someone who got an RFE, got on a denial, and let me take a look at the business plan that we didn't write. And two things that we identify very often, which is internally the business plan is inconsistent, and that's a lack of quality control, meaning the executive summary is saying that the company will hire 11 people, and then the staffing plan talking about 13. And wait a minute, is it 11 or 13? Now you're just giving ammunition to the immigration officer to just challenge everything, because I believe that the moment you identified an error, and this is human nature, you start kind of double, thinking or doubting, how about the rest? Can I trust the rest? Right? And I don't know if I told you this, John, but I was a college professor, and I remember whenever I was rating papers, first impressions count. The moment I started finding inconsistency, I started, wait a minute, I'm not trusting this document and the person behind this document. So you kind of get hard on, you grade that document with higher standards and higher scrutiny. So it's key to understand human nature. So consistent internally, but then very important, consistent with supporting documents. So whatever claim that the client makes about, oh, I invested X, Y, Z, show me the documents and make sure that this is aligned with the supporting documents that your immigration lawyer has, and so on. Show me the lease agreement, and we Google the address, and sometimes we find that the address shows something else, a different business, and then we start going down this rabbit hole. So it's very important that the business plan is consistent with supporting documents. Now, I'm not going to talk about removal condition. We only have 9 more minutes. That means, John, that, look, we wanted to talk about 3 case studies, right? Let's pick one. I propose, John, that we talk about the 3rd case study, which has been an ongoing project for years, that we initially wrote a business plan for an E-2 for one of your clients. Then that client transitioned into an EB-1C, and now we're updating that same business plan because there's a second E-2 applicant who's now qualifying for an EB-1C, and we're going to be again working with you to use that business plan for an EB-1C. So this is a company.
In that case, obviously they initially went for an E2 because they didn't want to, but they had the foreign entity that had an affiliation with a U.S. entity, and they kept it. They kept both operating. Initially, they did not want to be restricted by the time period on an L. So there was a conscious decision, a business decision done that, okay, I don't want to have a 7-year limit. I want to be here for whatever on an E2. But they kept both the foreign business and the US business operating. They kept the hierarchies. They kept all the requirements of the business. And obviously, they were the majority owners because they had the national of the treaty and so on and so forth. But over time, eventually, they had a desire to get a green card. And when, we looked at, how about an EB-5? Because the first thing that you think E2 is EB-5. What if I increase my amount of money to X and I have the 10 employees? On the X and EB-5, right now it's $1,050,000 or $800,000 back then. But, wait a second, but you still have this, you're the owner of that company over there, by the proper percentages, or the owners and the same owners here. So you're an affiliate under their requirements. And, EB-1C was a vehicle that we successfully used with your help, Marco, to be able to navigate that. But again, there's some circumstances, obviously, where the E2 doesn't lead to a green card. But if you do the right strategy, and what had discussed initially is, do we want to do an L? Because, well, why would you do an E if you could have done an L? And in that scenario, it's because they didn't want to be restricted. And at that point in time, they didn't want to be restricted by any particular period of time cap. And they just did not have a desire. What also allowed us to do in that period of time is tax planning, because they were very careful in time spent in the United States in E2 to do corporate tax planning. Because a lot of these strategies, Marco, really involve other issues, just not just immigration. And some of the clients that I do involve. So we had the E2 was devised as a tax planning strategy, as an issue that they didn't want to, and we did not want to foreclose the opportunity for a green card. And eventually, obviously, we kept those requirements for the EB-1C available, and we successfully navigated. But again, discussing business plans. I mean, one thing that I do, Marco, is you get your first L. When I'm doing a renewal, I'm sending it back to you to give me an update on the business plan. Tell me where now the entity is and where do you think it'll be going in the future. So I don't rely on a 3-year-old business plan or whatever. I want a new updated business plan, because companies, to me, a business plan, and correct me if I'm wrong, it's a snapshot in time. I take a picture of you today.
Exactly.
Today, that picture tells me where you're at, and it tells me where you're expecting me to go next. But a year from now, I'll take a different picture, and those may be different. And knowing the most accurate information whenever you do a renewal, whenever you do it for an employee or whatever, to me is critical, and having an updated business plan is critical whenever you're doing these new applications.
Exactly, but look, not only that, 2 quick comments, and let's open here the floor for questions. Again, adjudication standards, it's a moving target over time. So when the business plan was initially done, maybe 2-3 years ago, that snapshot was relevant and valid and really checked the boxes 3 years ago. Now, oftentimes it happens that when we're reviewing the plan, say, look, this narrative or this section of the plan worked 2 years ago, but now we have to change it to meet the current standards. And the other comment, and this is more from a business perspective, once you learn, and again, one of the first cases we did from E2 to EB-1C, I said, wow, why isn't everybody else doing this? Why? Not from a legal perspective, but as an entrepreneur, if I go for an L-1A, I have 12 months to grow my company like crazy. You're putting me this pressure, and I'm here thinking, should I invest? Should I do this? What if they deny the renewal? No, a businessman needs time to make sound business decisions without the constraint of, oh man, I have 10 months, 9 months, 8 months. It's stressful. So for me, of course, the foreign entity has to, there has to be the qualifying relationship. The foreign entity has to keep checking the boxes for an EB-1C. But for me, it's a no-brainer. That's what I would do from a business perspective. This is not legal advice. Anyway, Q&A. Let's see here what questions we have. Hold on, where am I? Okay, hold on 1 second. Let's see. Okay, Q&A. Here we go. Okay, first question is I should be sharing the screen so that, if the attendees want to, of course, reach out to John and his office, or we're also here to help. Here we go. Okay, no, not from starts. No, doing it wrong. My marketing team is going to say, oh, Mark, you did it again. Yes, I did. So here we are. Is a recording of this webinar available? Yes. What's your opinion on AI business plans? Okay. Let me share quickly. AI has no judgments, right? AI doesn't go to immigration conferences, right? AI will convince you, but do they know and understand current educational standards, challenges, what John was talking about? I mean, the different, your social media presence, the importance of consistency. But that's my take on AI business plan. And they all look the same. And since the USCIS is using AI, they're identifying any type of document produced by AI. What's your take, John, on AI business plans?
I mean, I really defer more to you, Marco, because I'll try to answer it this way. I think AI is a tool, but it's not. It cannot supplement the data, the citing, etc. And AI hallucinates. And what you don't want to do is use an AI feature for a quick, a cookie cutter business plan that gets submitted in a bunch of different places. Because, like you said, USCIS and the Department of State are using AI themselves to identify these things. So each business, even if it's the same restaurant, even if it's the same McDonald's, a McDonald's in New York is not going to be a McDonald's in Miami, and a McDonald's in
Exactly.
downtown Miami is not going to be a McDonald's in Coral Gables, Florida. So I don't think you can just have the same exact data for whatever the business is, and so
Exactly.
I think that it has to be tailored to individual markets and needs because again, I know a McDonald's operating in downtown New York is not the same as downtown Miami. There's different markets, there's different customers, there's different pricing of your products. So I just don't think an AI could incorporate all those things. And I think you also need the professional that if I'm litigating in federal court of denial, and if it goes to that, they say professional with standards. I'm not going to be able to say AI did it. And,
Exactly.
I just really think you need to use professionals.
Great point. It's about being ready for that litigation. Another question. This one's for you. It's already 1 o'clock, so I understand if you
No, no,
guys have to
we got
leave.
a couple more minutes. We could extend it
Okay,
to, a few
perfect.
more
So
minutes.
could you please expand a bit more on how social media can impact these applications? That's for you.
Yeah, actually, I was a part of a consortium called IBLE, which is different immigration lawyers. Immigration has already announced, so they're looking at social media, and I am aware of different uses of social media in some L context and some EB-5, whereby the person says, "I'm the CEO of the L company," and in their social media they're doing DJ skits in Miami Beach. This is an actual case. Now you
Mm-hmm.
could be the CEO of your company and you like to moonlight as a DJ. Get it. But immigration will pick up on some of these things. Immigration will pick up on some other things that you may be putting there. And they're also picking up on things that I've never seen before. And I think you mentioned one where they're now denying certain visas. It's more on the EB-2, but nothing prevents an L or whatever. Um, that they're denying it for example, liking posts that they think are un-American or could espouse terrorist ideas or whatever the case may be. Whether you show opposition or support for Palestine or against Israel. So they're looking at social media in many different ways, including sometimes it's about does it confirm what you're doing with your L or your E or your EB-5? When you said you were the manager abroad and it shows in your social media that you lived in a different city, etc. So there are some things. Now I will give a company that I recently learned, and I am advising some of my clients to look at, in the sense that I think it's called WeCheck, and they looked at this is done for anyone, not just visa people work. WeCheck is a website that looks at your social media presence and determines whether there are problem areas and attempts to fix it. Now
Interesting.
you cannot erase from eternity whatever you posted or liked or anything, but that company can assist in identifying areas of weaknesses or areas where I'm advising some clients that look, maybe you should. I'm not the FBI. I'm not going to go look into your social media. And we know that
Exactly.
at the consulate, they're required now to give passwords and things on social media. Maybe I expanded too much, but it matters.
It matters a lot. But just to add something to your point, which is I attended the ALA conference in Barbados, the Latin American chapter conference in December, and one of the panelists, an immigration lawyer, was sharing the story with the attendees that there was someone's O1 was denied not because of the applicant's social media, but his wife in 2016 had liked a comment that the current administration that he didn't like. So it
I know
was
one
the,
case, Marco,
the
where
wife.
correct. I know one case, and this you couldn't fix though. I know one case of an O1 artist that got denied the O1 visa because the lyrics on the songs he had written, they consider to encourage violence.
Wow. Okay.
Now you can't fix that because that was his art. But
Exactly.
you're looking at different things, and WeCheck AI is, I mean, if you want to look at it, it's a company that recently learned that looks at your web presence, you look at your social media, and attempts to correct it. But what I tell people is, and in the marriage context, has happened is, be careful what you put out there. I mean, once you put it out there, is
Okay. Yeah. Well, thank you, John. We have one final comment here from one of the attendees saying, just want to chime in and say that John is 1000% correct, 1000% correct on all his points. So I agree
Thank you very much for saying that. And again, I'll just simply conclude this. When I started working with you, Marco, I mean, like I said before AI, there were I don't know where they got it, but they would make them up. You need a professional like you, like your company, with real data, with really sites, with really things, with market studies, etc., to determine what a good business is. And a lot of people think it's just for the visa. If your business succeeds, if your business makes money, if your business pays people, your visa will come along with it. Because if you invest in a business, or if you do a business that does not succeed because it's not supported by a good business plan and a good roadmap of what the business is and what, you will fail, both in immigration and as a business venture. So, business
Exactly.
plans were created outside of immigration to help businesses succeed, Marco.
Exactly. It's a flight plan. Simple as that. Well, thank you, John. Thank you for joining us today. It was great. Thank you to all the attendees, and you have a great rest of the day. Bye-bye.